The Supreme Court came down this morning with a couple of consequential decisions, and one of them I think is exhibiting actually a trend that I believe is being led by Justice Scalia, who you know I'm no fan of, but I think it's a fascinating phenomena, his shift to the libertarian, shall we say. I won't say to the right. Ian Millhiser is on the line with us. He's an attorney, constitutional policy analyst with the Center for American Progress. He's the editor of Justice, Think Justice? It's the Justice site of...
Progress Justice.
Sorry, say it again?
Think Progress Justice.
Think Progress Justice. Thank you, Ian. Welcome back to the program.
It's good to be here. Thank you.
The two cases that are probably getting the most flash today are the Aereo case and the cell phone case. Why don't we go through those to start out? Tell us what the court said with regard to if they stop your car, bust into your house, whatever it may be, and you've got a cell phone on you, and what has been common practice is they simply take that phone and start looking at anything that's not secured. And so what's the situation now?
Oh, sure thing. So this is the Riley case. What happened here is that there's a long-standing rule saying that when you are placed under arrest, the police don't need a warrant to search anything that's on your person. So like the seminal case in this space dealt with a pack of cigarettes, and the police found a person who had a pack of cigarettes on him. They then searched him. They took the pack of cigarettes. They rifled through it. They found evidence of a crime in the pack of cigarettes, and the Supreme Court said that that could be done without a warrant. So what the government claimed in this case is they claimed essentially that cell phones are just like a pack of cigarettes. If the police want to open up your pack of cigarettes, they can look through it, and if they want to search through everything on your cell phone, the government argued that they should be allowed to do that too when they arrest you.
Right, and the other side was arguing that was essentially your papers, possessions, that you need a warrant to do that.
That's exactly right. They said that this exception, that this rule that says that when you are arrested, the police can search you, it shouldn't apply to cell phones, and the Supreme Court agreed. And they agreed, I think, on pretty sensible grounds. Think about what you could access from a person's cell phone these days. You get all their emails. You can potentially find out detailed financial information about them, detailed information about their professional life, who their romantic partners are, potentially very intimate details about their sex life. All of that is contained in these tiny little computers that we all carry around in our pocket.
Right. And just... Yeah, I'm sorry.
Go ahead.
Well, I was... Go ahead.
Go ahead.
You must be on a cell phone.
Yes.
We have a time delay. So finish your thought.
Oh, yeah. So what the court said is that these cell phones are different than anything that's come before. When our Fourth Amendment law was designed, this technology didn't exist. We didn't know the implications of saying police can search anything on your body. And so now the rule has changed. Now, unless there's some crazy exigent circumstances, like there's a bomb that's going to detonate, they need to search the cell phone to stop it, the police need a warrant every time they want to search someone's cell phone.
Right. And the basis for this, for people who are not immediately familiar with what Ian and I are talking about, is the Fourth Amendment, which is basically, one sentence. I'll read it. The right of the people to be secured in their persons, houses, papers, and effects, which is what the court has ruled a cell phone is, against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. In other words, somebody has to go before a judge and say under oath, I think that there is a crime being committed, and the judge then issues a warrant, and then the search can proceed. Right?
That's exactly right.
Okay. So, this is a good, I think this is a good trend and a good decision, frankly. Your thoughts?
And surprisingly, it was a fairly wide decision. It was a 9-0 decision, although only 8 justices joined Roberts' opinion. Alito wrote separately, as he often does in criminal cases.
Why is that?
Alito, I think, is very gung-ho for prosecutors.
He's the law and order. He watches too many cop shows.
He has participated in too many cop shows. He's a former prosecutor himself, and I think he's still very sympathetic to that side. But he's only one vote. There are 8 justices who joined Roberts' opinion.
Yeah. Okay.